Good evening to all of you. I'm Yashasvi Sharma, member of Legal Vidya. Would like to take this opportunity to host a highly anticipated webinar on the topic of intellectual property issues in sports business. In this webinar, we will navigate the ever evolving landscape of sports, characterized by the intense competition and continuous innovation, which demands a keen awareness and adapt management of intellectual property considerations. This webinar fosters a deep exploration of the nuances of intellectual property in the context of sports business. Before we begin, I would like to introduce Legal Vidya to all of you. Legal Vidya is a platform that was founded in the year 2021 with the vision of empowering young lawyers. Our organization provides a comprehensive portal where people share their expertise in the field of law. Legal Vidya offers various opportunities such as internship programs, a platform to publish articles, and also host interactive webinars and seminars for law students. And this is an evident example of it. Now, with great pleasure and honor that I introduced our distinguished speaker for today's webinar, Dr. Gururaj Devarhubli from Gujarat National Law University, specializing in intellectual property laws. Notably, he excelled in the NTA UGC NET examination in his first attempt. Currently, an assistant professor at Nirma University. His prolific contributions to legal literatures reflect a commitment to advancing knowledge and fostering intellectual discourse. Let us warmly welcome Dr. Gururaj Devarhubli to the virtual stage. We eagerly await the wisdom and perspective that you will share with us, sir. Over to you, sir. Thank you.
Yes, thank you, Yashasvi. I hope I am audible and visible clearly. Okay. Let me just share the PPT. Yes, is this PPT visible to everyone? Okay. So, good evening, everyone. I, Gururaj Devarhubli, will be speaking today on the topic of IPR issues in sports business. Now, this particular topic is very interesting. First of all, not only because it talks about intellectual property, which is my area specialization, but also because it talks about the intersection happening between the intellectual property and particularly in the sports arena, because sports is a very dynamic area, particularly when we talk of the intricacies involved in the sports area. Because of that, there are several intellectual properties involved in this particular area, in the sports area. So I'll be discussing how what are the various issues which are coming up in the sports area, and how the courts of other countries have adopted measures to maintain a balance between intellectual property and the sports persons. Now, let me just ask you, what is the purpose of intellectual property? Out of all these five, somewhere these are the various purposes of intellectual property. It basically is incentivization. It basically provides a certain incentive to the creator who has created a particular musical work or a film or a painting or a particular photograph. The purpose of intellectual property is to incentivize the creator. The second is to reward the creator. Now, that reward can be either in monetary form or in by way of exclusivity. The third purpose of intellectual property is innovation, because it basically, when a particular person has uh, got a particular protection over his innovation, then in that particular case it motivates other people to create similar innovations, so that they can get protection, intellectual property protection over their work. So the third purpose of IP is innovation. The fourth is creativity, because it again enhances the creativity of other people, because they get motivation to come up with new works which are creative, which are original, which are helping the society. And say similarly, it also um, helps them in maintaining their exclusivity over the particular work. And the last is disclosure and human progress. Now, intellectual property protection, when we talk of a copyright or patent protection, is available to the creator only when he or she discloses the particular work which they have created. And the purpose of such work should be human progress. So, out of all these things, these are the various purposes of intellectual property. Now, if I ask you, what is the purpose of sports? Can anyone answer? What is the purpose of sports? Can it be said that out of all these five are also the purpose of sports? The purpose of sports is incentive, reward, innovation, creativity, disclosure, and human progress. Can it be said that the purpose of intellectual property and the purpose of sports are very much similar? Because if you see this slide, the purpose of sports is again by and large very similar to intellectual property, because the purpose is incentive to reward the sports person who has performed a particular task. Out, if there is a running race, the person who has come first, he will be rewarded, he will be given certain incentives. That incentive will not only be monetary but also will be through his identity, brand identity, and the endorsements which he will be doing. The third is innovation. For example, if a particular person performs a particular move which is very innovative, then that particular purpose will also be achieved. The fourth is creativity, because as I said earlier, sports is a very dynamic. It is very necessary for the sports person to be very creative and to be very dynamic. That is the fourth purpose. And again, disclosure and human progress. So the ultimate purpose of intellectual property and sports is by and large very similar, because of these five reasons. Now, let me just show you a particular video which will help you to understand the intersection between intellectual property and sports in a better way. This is a now, based on this particular video which you have seen, um, can a sports move which has been done by a sports person, can it be given any intellectual property protection based on this particular video? Because Fosbury flop is the only way which is being used in high jump. So can Fosbury, big Fosbury, when he first did this particular move, can he claim IP protection over it? Or let's suppose if MS Dhoni has done the helicopter shot for the first time in any particular match, and in order to gain some exclusivity and to monetize that particular move, can he claim some IP protection over it so that others cannot do it without obtaining a license from him? Now, in that particular case, there are several IP issues involved here, and not only one IP is involved. There are several IPs like patent, trademark, or copyright is involved in the area of sports. I'll discuss the first intellectual property, but before going into that, when we see the intersection happening in the IPR and sports area, it can be said that this intersection is not only on the field, on the playing ground when the where the sport is being played. For example, if a cricket match is being played, then the intellectual property is not only on the cricket field but also outside the field, off the field. So On the field, there are intellectual property questions like with respect to equipments, with respect to the sports techniques which is performed by a sports person. And off the field, it is basically the business model of the sports, over which IP protection can be claimed or not. So when we talk on the field, basically it involves majorly patents, because it can be patented whether sports equipment can be patented, whether a sports technique can be patented, or a sports move can be patented or not. This is the major issue, this is the major IP involved on the field, when we talk of IP and sports. But when we talk off the field, there are copyright and trademark involved. Copyright with respect to the broadcasting and media rights of the particular sport event. For example, uh, World Cup is being played, or for example, FIFA World Cup is being played. So, what all, which uh, television company or which TV agency has the broadcasting right or the media right over that particular sport? That is that involves copyright. For example, similarly, broadcast reproduction right is also something. For example, if Star Network is the official broadcaster of a particular World Cup, then it also has the right of broadcast reproduction, right? Because any other channel, for example, if there is a news channel which is showing certain clips of the World Cup, then they have to obtain appropriate license from the Star Network before playing that particular clip on that television channel, on that particular channel. So it involves question of broadcast reproduction right. Another IP involved off the field is trademark, because there are questions of sponsorship, endorsements, and merchandising which is involved off the field with respect to trademark. So, if, for example, if a particular person's jersey has certain brands like Amul or certain other companies, then they are the sponsors of the particular team. Similarly, there are certain events which have certain sponsors. For example, similarly, there are certain merchandising which is done. Endorsements, for example, if then a team player is doing any endorsement, then can he endorse a particular brand which is not the official sponsor of his particular team by wearing that jersey? For example, Virat Kohli is part of RCB, the Royal Challengers Bangalore. If Virat Kohli is wearing the RCB jersey and he is endorsing a particular brand which is not the official sponsor or is not the sponsor of RCB. For example, if he is endorsing Vimal brand, Vimal Ilachi, particular tobacco product. So, can the sponsors of that particular team, RCB, can they have any right, because their right is being violated in some other endorsement which is being done by Virat Kohli in his individual capacity? So, all these are issues which are involved here. So the interface of IPR and sports involves these major IPs: patent, trademark, copyright, and trade secret. But I'll start with patent and sports. How the interface is happening between sports and patent. So the sports and patent are basically have an interface because of the equipments which are being used. For example, if you see this image on the first image on the left hand side, the image is of a particular football which was patented in 1914 in USA by the US Patent and Trademark Office, and a patent was granted to this particular football. Similarly, a cricket ball has been patented in USPTO, and a bat, a particular mongoose bat, has been patented in USPTO. The reason is majorly the all the sports equipments which you will see, which are being used as a timer or as a equipment in sporting events. Most of these equipments have been patented in the USPTO, which is the United States Patent and Trademark Office. This is the reason is they cannot be patented as such in India. Similarly, they cannot be patented under the UK Patent Office or any other country's patent office, Japan Patent Office or China Patent Office, but most of it has been patented in USA. Now, the reason is USA has a particular policy which is known as everything under the sun made by man is patentable. So whatever is there, whatever is existing, whatever thing is existing in on this planet, on Earth, and if that uh, a thing has been made by man, then it can be patented if it satisfies the criteria of patentability. So US has a very liberal approach towards patent, towards the granting of patent, because they have follow everything under the sun is patentable criteria. Uh, but in India, if you see, Section 3 and 4 of the Patents Act 1970 provides a list of inventions which cannot be patented. And one of the clauses of Section 3 says that the method of playing a game or a mental act cannot be patented. So if Virat Kohli or MS Dhoni has performed a helicopter shot, then he cannot obtain a patent, even though he was the first person to do that particular thing, the helicopter shot. But that is a method of playing a particular game. There are several ways of playing a game. So there is not one method of playing, of putting a ball or doing a shot. So everyone has their own technique. So because of that restriction, because of the restriction in Section 3, that a method of playing a game cannot be patented, MS Dhoni or any other sports person, if he has performed a sports move, he cannot obtain a patent. Similarly, sports equipment have not been granted patent in India so far. The reason is, again, sports, the purpose of sports is to enhance creativity and to basically make the sports uncertainable. For example, just the best example of is last week we had the World Cup of cricket and India lost to Australia. Now, let's suppose there is a particular equipment which is being utilized by India, by the Indian team in the World Cup, and because of that particular equipment, if there is a particular bat which being used exclusively by the Indian players, Indian batsmen, and when they use that particular bat, uh, the player always hits a six or a four. The possibility of a player getting out is very less. Let's suppose now, because of that particular thing, because of that equipment, the purpose of sports is underutilized or it futiles, because the purpose of sports is to have an uncertainty in the game. So till the last minute, the audience will not be knowing who will be winning the game. It can be either India or it can be Australia. But for example, if we see that there is an equipment which is being used by the Indian player, by the Indian team, and the batsman who uses that particular bat will hit a six, surely hit a six. 100% he will hit a six. Now, because of that usage, the audience's interest or the possibility of having a different result will not be there. So the possibility of having an uncertain result will not be there. Because of this, the interest of the audience will not be there. So if the news channels show that Virat Kohli will be using a particular type of bat, or Rohit Sharma will be using a particular type of bat, then the interest of the audience will be minimized, because they probably will know the result, outcome of the match, that India will win because Virat Kohli and Rohit Sharma are using these type of bat. Now, because of this purpose, the IP authorities or the agencies in India, they have not given patent to sports equipment. Similarly, they have not patented any sports move because of the restriction provided in Section 3. But when we see in USA, these are certain equipments which have been patented, like golf club, gym equipments, the sports drink which are being used by sports persons, and muscle building and nutritional supplements are also patented. Because the criteria for patent in USA is usefulness, novelty, non-obviousness, and described adequately. So all this can be done with respect to a sports equipment, because, for example, if there is a particular golf ball or a golf club which can be used while playing the game of golf, then it is useful. The usefulness criteria can be shown there. It is very novel because no one else has used it before. It is non-obvious, that can also be shown, and it can be described adequately. If a particular person wants to obtain a sports patent on a sports move, he can describe that particular move, what type of body movement he is doing. He can show that movement, and he can describe it by certain images and diagrams, so that adequate description can also be done. Now, patentable subject matter again is the invention should be a new invention, inventive step should be involved, and industrial applicability should be there. This is the criteria for obtaining a patent in India. Now, the second intellectual property which is involved is basically the interface between trademark and sports. Now, all these images which you are seeing, all these companies or all these teams have obtained a trademark over the logo which is being shown. So when we say the trademark of a particular sports, trademark is something which not only protects the event but also the team involved participating in the particular event. For example, if you see on the left hand side, there is a image of a player with a bat and making a shot. Now this is the image of the Indian Premier League, IPL. So there is a separate intellectual property, there is a separate trademark protection for this particular logo. Similarly, for each team which is participating in IPL, whether it is Kolkata Knight Riders or Chennai Super Kings or Mumbai Indians, all these teams also have a separate trademark. So the trademark is something which not only protects the interest of the sporting agency, which is organizing the sports event, which is the IPL, but also the players or the teams which are participating in this particular event. Similarly, there is a trademark protection for Olympics, and there is a particular regulation with respect to the which prevents the misuse of the Olympic logo and the Olympic sponsors. So if there is a particular team which is if there is a particular company which is sponsoring the Olympic, then for before each Olympic, there are regulations which are coming up, and these regulation prevents any company, any person, any third person from using the logo of Olympics and the sponsors who are sponsoring the Olympics. Now, one of the interesting practices which is done with respect to trademark and sports is ambush marketing. Now, ambush marketing is something I'm sure you are already aware about the trademark law. And in trademark law, in the Trademarks Act of 1999, there is a particular provision, a section which is section 29, and in section 29 there is one clause which is clause 8, which provides for comparative advertisement. Now that particular clause says that a person or a company, an entity which has a trademark, it cannot it can promote the products of its own. For example, if I am Amul company, I have certain ice cream product, I can show that my ice cream products are very good, they are of very good quality, they are made of pure milk, pure butter, and pure dry fruits are being used in my ice cream. But just to show that my products are very good, I cannot demean any other company. I cannot say that other company like Vadilal or other company, other ice cream manufacturers are misguiding, or they are not using real products. So in that particular case, that would be comparative advertisement. So that cannot be done. But there are certain ways of advertising a particular product. Now, another kind of activity which is done in with respect to sporting events is ambush marketing. Now, in that particular cases, this particular term, ambush marketing term, was coined by a particular scholar, which was Jerry C. Welch. Now, he says that it is a marketing strategy that uses the same themes as the sponsors to weave them for marketing eminence. Now, basically, this particular image will help you to understand ambush marketing. Coca-Cola has shown a particular hoarding, and they have mentioned Coca-Cola's second floor. Just below that hoarding, Pepsi has put another holding of theirs, and they have said Pepsi everywhere. Now, um this shows basically that they are putting the hoarding. So ambush marketing is something where a company puts their hoarding towards, or puts their advertisement very near or in close vicinity to another competitor's hoarding or banner, and they mention it in such a way which basically motivates the people or the audience or the consumer to utilize their product. So if I'm seeing this hoarding, I will be more utilized, or I will be more interested to see the product or utilize the product of Pepsi, because they are everywhere. So it creates a kind of impression on the minds of the public. So that is ambush marketing. I'll show some images in my next slide, which will help you to understand here. Now, ambush marketing is something, when we see comparative advertisement and ambush marketing, they are both related to marketing strategies, and both are done in an advertisement manner. But there is a very slight difference which is there with respect to both these activities. First is comparative advertisement is basically comparing two products. For example, Flipkart and Amazon. So if Amazon has come up with certain big sale, Flipkart would also come with that particular sale, and they would mention it in such a way, or they would mention that Amazon's sale is not good, so people should purchase our product, should participate in this sale, Big Billion Day sale, which is organized by Flipkart. So that is comparative advertisement. But ambush marketing is a very restrictive type of practice which is done, because it is usually done during the time of a particular event which is being organized. For example, if you see here on the left hand side, the image which is there, this is a hoarding which was there during the time of 1996 World Cup, and in that Pepsi had come up with certain hoarding. Now, in by that particular time in 1996, Coca-Cola was the official sponsor of the ICC World Cup 1996. Pepsi came up with certain hoardings, certain advertisement, and that advertisement featured certain prominent cricketers like Sachin Tendulkar and Mohammad Azharuddin, and they mentioned that nothing official about it. Now, this creates an impression in the mind of consumer that it's not Coca-Cola, but it is Pepsi which is the official sponsor, or which is connected with the ICC World Cup. So the purpose of ambush marketing is basically to create an impression in the minds of the public, so that they associate their product, their company, with a particular sporting event. It can be either related to cricket, or it can be with respect to football or any other event. Now, if you see this image, which is of a newspaper, and this advertisement came in the newspaper Times of India, and on the front page there was an hoarding of Snapdeal, which read, "For others, it's a big day. For us, today is no different." Because on the same day, Flipkart had announced that the Big Billion Day sale would be going live. And today, don't look anywhere else. India's greatest sale ever is here. Flipkart, the Big Billion Day sale, starting today from 8 a.m. So this was the hoarding, this was the advertisement put by Flipkart. On the same page, on the same paper, on the front page, Snapdeal advertisement read, "For others, it's a big day. For us, today is no different." Now, here, it is not related to ambush marketing. This activity of Snapdeal, or this practice of Snapdeal, is not related to ambush marketing, because it is not related to certain sporting events, but it is a kind of comparative advertisement. They are comparing their products or their company to other competitor company. So this is the difference between comparative advertisement and ambush marketing. Another kind of example which you can see here, in 2012, during the London Olympics, if you see here, um, during the Paralympic Games, this was a company which was showing a particular hoarding which was very near to the place where Olympic was being organized, Olympic games were being organized, or Paralympic Games of 2012. They said that official sponsor of the largest athletics event in London this year. They put it in a very big font, and just below that, in a very small font, they mentioned, "There you go, we said it." So this created an impression in the minds of the public that perhaps this company is the official sponsor of the London Paralympic Games of 2012 and not some other company. But even though this company was not the official sponsor, they used it and they got away with it without any uh, offense of ambush marketing. Now, it is very difficult, first of all, to prove ambush marketing because when we see comparative advertisement and ambush marketing, comparative advertisement, the courts have laid down certain guidelines with respect to comparative advertisement. There are certain 5 or 6 guidelines which should be satisfied, and which says basically what can be done and what cannot be done in comparative advertisement. But when we say of ambush marketing, the approach of the court has been very different because it depends on the way the product has been advertised. So uh, Snapdeal may or may not lead to comparative advertisement. It will surely lead to comparative advertisement. But here, if you see this image, it may amount or may not amount to ambush marketing. It depends on the facts and circumstances of the case. So there are no strict guidelines with respect to ambush marketing. So the courts have decided based on the facts and circumstances of each case. Now, next important kind of issue with respect to intellectual property and sports is the celebrity and image rights. Whether India or whether any particular celebrity or a sports person can claim any image rights over their particular usage of image or a particular work which they have done. For example, uh, if they are part of any advertisement, then whether that advertisement when it is being shown on TV or some other platform, whether it can be utilized for some other purpose, or certain images from that advertisement clip can be utilized for some other purpose without the permission. Because if it can be utilized, then it means that such celebrity or sports person does not have any image rights. But if a permission has to be obtained, then it means that they have image rights over the work, over the image of theirs. So before going into this issue, personality is something which is basically a combination of characteristics. So they are known as personality rights. In some jurisdiction, they are known as celebrity rights. In some jurisdictions, this right is also known as image right. But personality right is a very apt term because when we say image rights, it basically shows that the image of the sports person. Or when we say celebrity right, it basically means the rights of the celebrity. It can be of various nature. It can be of publicity, it can be of privacy, it can be of freedom of speech and expression. So that is there. But when we say personality right, it is a very clear term because personality, it can be of a very famous person, and whether he has the right over his personality or not. So if Amitabh Bachchan has a particular way of talking or way of walking, then whether he can claim any protection over this work or not, over his personality or not. But before going into that question, personality is something which is a combination of various characteristics or qualities that form the individual's distinctive character. Now, that personality, when we say Amitabh Bachchan, that personality of Amitabh Bachchan is not only because of his height or his particular voice, but it is a combination of different attributes of that particular person, of that celebrity. It can be either his uh, way of talking, it can be his way of expression, his particular face which is there, or his particular height, and is also hairstyle, and also the other characteristics which are there. For example, the name of Mr. Bachchan or the voice of Mr. Bachchan. So that is very unique. There is no other alternative to that particular thing. So when we talk of celebrity or image rights or personality right, there are two rights which are majorly involved here. The first is whether the personality has the right to control the publicity of his, whether he has a right to publicity, and the second is right to privacy. Right to publicity is a very positive right, because it says that when a particular person, when a famous personality has achieved something, when he's famous among the masses, then whether he has the right to use, decide his publicity as to in what way people should see him, whether it can be in advertisement, whether in it can be through certain events which he is organizing, or the films which he is doing. So that is right to personal publicity. Second right is right to privacy. Now, when a particular person is doing, for example, Virat Kohli is participating in some event, whether he has the right to protect his images, or the person, because today everyone has a smartphone. Now if I click a photo of Virat Kohli in a very compromising position with some other person, or a particular with his wife, now whether he has the right to privacy in that particular case, because he is at a public place. So in that particular case, whether he has the right to privacy, or his right to privacy is bypassed in such case. These are the two various rights which are in question with respect to personality. I'll answer it in my next slide, but these are the various issues. Now, proactive. There is one important case with respect to celebrity and image rights. Proactive Sports Management Limited versus Rooney and others, decided in 2011. Now, Rooney was a uh, famous player in 2004 and 5, and what he had done is he had assigned his image right. He had created an agency, and he assigned his right to that agency, and that agency, on behalf of Rooney, the sports person, they entered into certain contract with some company for the usage of image of Mr. Rooney. So this is the sequence. Mr. Rooney is a famous player, famous sports person. He created an agency. He assigned his right of image rights to that agency, which can be utilized with his permission. And when that company assigned that particular image right to some other company, the company gave certain benefits, certain amount as fees to Mr. Rooney for his image rights. Now, after 5 years of working, Mr. Rooney, the agency which had transferred the image rights of Mr. Rooney to other company, they withdrew the assignment and they gave it to some other company. Now, the other company, which is the Proactive Sports Management Limited, they approached the court here, saying that it is a right, because of this abrupt withdrawal from Mr. Rooney's agency. They have suffered huge losses, and they should be given back this right of image, and they should also be uh, satisfied with respect to monetary losses which they have suffered. But the interesting part was Mr. Rooney, when he entered into an assignment with this company, the Proactive Sports Management Company, he was a minor. He was of around 16 years or 17 years of age, and he assigned his right to the company, and that company gave the right to Proactive Sports Management Company. So here, the assignment was done when Mr. Rooney was a minor. So based on that fact alone, the court dismissed the suit filed by Proactive Sports Management Limited, and they said that as Mr. Rooney was a minor, and the agreement which was done between them and Mr. Rooney is void ab initio. Now, again, with respect to image rights, these are certain images which you can see. If you purchase a shirt, kind of t-shirt, you'll see various t-shirts with various sports persons images there, notably MS Dhoni and Virat Kohli and Rohit Sharma. And this particular image, if you see, which is being utilized by which has been shown by a particular university, they have blurred two numbers 3 and 7 So they have said that these spaces can never be filled. 3 is for Suresh Raina and 7 is for MS Dhoni. So when they retired, these sports persons retired, they came up with this image. Now the question is whether the company, whether the sports person has any image right available here. Now it depends on the jurisdiction where they are approaching. For example, in India, we do not have as such any right as known as personality right or image right, but in few cases, the courts in India have recognized this right. I'll discuss that right, this case laws in my next slide, but that depends on the jurisdiction where they are approaching. For example, in 2021, there was a particular case, if you see, of where Amitabh Bachchan's voice was being utilized for some other purpose, and the court came up with injunction order preventing the other company from using Mr. Bachchan's voice. So that is a particular case on image right. Now, with respect to the regulation of celebrity or image rights, as I said, as we have UDHR, you must all be aware about UDHR, the Universal Declaration of Human Rights. Similarly, in 2017, there was a Universal Declaration of Players' Right, which was recognized, and this declaration has provided certain rights to the players, irrespective of the game where they are part of. In USA, there is a legislation which is the Lanham Act of 1946. In UK, as such, there is no specific statute for protection, but the right of celebrity or a sports person can be protected by way of trademark or by way of passing off right to privacy and data protection law. But in UK, one of the islands of UK, which is the Guernsey Island, they came up with a law, which is the law on image rights, and they laid down certain guidelines as to when an image can be used and when it cannot be used. Now, with respect to India, there are few cases which are there. For example, the first case was with respect to Mr. Daler Mehndi, where certain toys were there with respect to Daler Mehndi, which were replica of Daler Mehndi. The way he styled, he put a turban, and it was in a dancing mode. So the court said that it is without the permission of Daler Mehndi, so it is hampering the image right of Mr. Daler Mehndi. The second case is with respect to Mr. Bachchan, where his voice was used without his authorization, and the court ordered that they should not utilize such voice without the permission of Mr. Bachchan. So they passed an injunction order in that matter. Now, when we say the Guernsey law on image rights, they came up with, they basically first of all defined what are image rights, what it involves. It involves the voice of the person, the signature of the person, likeness, appearance, silhouette, feature, face, expression, verbal and facial, gestures, mannerism, and any other distinctive character or personal attributes or personage, and any photograph, illustration, image, picture, moving image, or electronic or other representation. All this is involved in image right. So over all this, a protection can be given to the sports person. Now, with respect to the regulation, these are the various cases which are there. One important case is the ICC Development International Limited versus RV Enterprises. In this, one interesting observation was done by the court, where they said that the right of publicity has evolved from the time of privacy and can inhere only in an individual or any Indian of an individual's personality, like his name, personality trait, signature, voice, etc. An individual may acquire the right of publicity by virtue of his associate with an event, sport, movie, etc. Now, the Russian Civil Code has basically provided that a person's consent, when a person's image is being used for any newspaper or for certain website, then the consent of such persons should be utilized, should be obtained before using such image. But in some cases, the permission or the consent of such person is not required. There are certain exceptions with respect to the obtaining of permission. The first is if such image is used in a state, social, or other public interest, The second is if such image has been obtained in a place with free access or at a public event. For example, if there is a charitable event which is going on, or if for example if the sports person or any movie star has been called for inauguration of a particular event, then in that case, because it is of a free access, or it is a public event like a congress or conference or concert or show or sports competition, then in that case the consent of such person is not to be obtained, except for cases when such image is the main object of use. So for example, if for example Varun Dhawan has been called for inauguration of a particular hotel. Now the usage of Varun Dhawan's image is the main activity there. Okay. For example, Varun Dhawan is cutting the ribbon of the hotel for the inauguration. So that is the main image of the hotel. That is the main image of the event. So for before publishing that particular image, or before using that image, the consent of Varun Dhawan has to be obtained. But if Varun Dhawan is talking to some other director at a public event, or he is talking to a particular minister, chief minister of that particular state, and he's talking to on a general topic, then the image has been obtained, then in that case the consent of Varun Dhawan is need not to be obtained. Or if the third purpose is if they have been paid for modeling. So if any model or any film star or a cricketer or sports person has been paid for modeling, and that image is being used for modeling, then it can be circulated or it can be used without the consent of such person. Now when we talk of marketing, there is a one interesting type of marketing which is done, which is movement marketing. I'm sure you must have seen these kind of marketing strategies which are being adopted by companies on Instagram or on Twitter or on other platforms, social media platforms. So movement marketing is a very kind of new concept which is there. Movement marketing is a marketing strategy where brands take the advantage of the ongoing events and try to gain relevance by inserting themselves into ongoing conversations at a marginal cost. So, for example, if Shikhar Dhawan has hit a century, or Virat Kohli has hit a century, then in that case they come up with certain congratulations message. Or if PV Sindhu has won a particular bronze medal, or Neeraj Chopra has won a gold medal on javelin throw, they come up with certain images which are congratulating the sports person. Now the question is whether these kind of advertisements or hoardings, whether they amount to infringement of copyright or trademark of that person, because obviously the consent of the sports person is not obtained in doing that, because they come up with that particular moment. For example, if today PV Sindhu wins up a particular medal, in tomorrow's paper it would be coming up on the front page of any newspaper, or Amul would be coming up with such hoarding on their platform the next day on Twitter, on social media, on Instagram and other platforms. So they would not be obtaining consent all the time. Neither they have obtained consent on the first time when they are doing it. So the question is whether it would amount to infringement. So to determine movement marketing, there are certain tests which are required to be satisfied. First is what is the motive or intent behind borrowing someone else's work without authorization? Whether it is basically to create their own brand, to enhance their profit, or to it is only for promotional purpose. Second is, are they hoping to piggy bank ride on the popularity or recall value of the borrowed work? Third is, what is the overall impression that the campaign hopes to leave in the minds of the audience? And is the borrowed extract an essential part of the material being borrowed? So the question why, whether it would amount to infringement or not, why this question came up is, for example, if Amol has come up with certain brand. For example, let me show you this image. All these images are with respect to PV Sindhu when she won a particular medal in final titles. So, do you think PV Sindhu is the brand ambassador of any of these companies? Wherever her image is used, do you think she is the brand ambassador of this image, whether it is of Apollo or Pan Bahar of a university or Aditya Birla? All are utilizing her images. So does it create an impression in the mind of the consumer that PV Sindhu is the official sponsor or the brand ambassador of this company? Now here, because of this issue, whether what is the intent of using the image? That is the first question. As I said, the first test to be satisfied is whether the usage of the image of the sports person or celebrity is with respect to promotion of the company, or it is only given as a gesture for the achievement which the sports person or the celebrity has done. So all these companies are basically congratulating PV Sindhu for her achievement, but at the same time they are also using their company's name there. They are mentioning the name, the image of the sports person, and they are mentioning the product of theirs on the same image. So whether it would amount to movement marketing and whether there would be any celebrity rights involved here. Now PV Sindhu had um, sued all these companies, all these brands, wherever her image was used without her permission. And the question here was whether the court would be recognizing image right of PV Sindhu in all these matters or not. The matter is still pending. So these are some other examples where PV Sindhu's name was used without a permission. It was for Vicks, Pan Bahar, and again for Happydent. Now, the last interface which we'll be talking about is um, interface between copyright and sports. It is a very interesting area of sports and copyright because it is off the field, this type of interface which is happening, but it is mostly with respect to the broadcasting which is done. For example, if there are if Star is the official sponsor, official broadcast partner of the World Cup, Cricket World Cup, but there are certain other third parties, there are certain other websites which have come up which are illegally streaming the World Cup matches on their platform, which is hampering the revenue of the Star network. So, in that particular case, what will be the scenario? So, one of the major issues of copyright and sports is the piracy of the sporting event, which is being done. So, these are the screenshots of certain websites. The first is there are certain torrent files which are available, and these torrent files have the matches or the clips of a certain match which are recorded and which is being available on a free basis to the consumer, to the person who can download the torrent file. Similarly, there is another website which is tennis3.tv, which basically has recorded certain tennis matches which were being played, which were being streamed on certain official channels, and it is being made available here on a free basis. So the question is, what remedies do the people have against this piracy activity? Now in India, when we see the most of common remedy with respect to piracy of sporting event is the obtaining an injunction. So it can the people, the third parties who are doing such illegal activity, they can be prevented from doing that activity. They can be prevented, they can be told of not doing that activity because it hampers the copyright of the copyright holders. Similarly, because injunction has failed in with respect to copyright matters, copyright works, the courts have come up with certain new kind of remedies. Because piracy is now being done digitally, the courts have come up with website blocking orders where they block a particular website. So if I want to access tennis.tv on my computer, then I cannot access this because it has been blocked in the Indian jurisdiction. So anywhere in India, anyone in India wants to download anything from this particular website, it has been blocked by the uh, agency. But another type of remedy which is being extensively granted by the courts is dynamic injunction. Now, what happens is, if you see this image of tennis.tv, that is the official name of the website. But because the website is being continuously blocked, it has been blocked by the Indian jurisdiction. So what they do is they come up with a new domain name. For example, they come up with tennis.tv.tv. So that domain name is not blocked. So again, the people can download illegal recordings there, and they can utilize it without permission. So the copyright holder would have to again approach the court for blocking that uh, website. So that is a kind of new remedy which is done, dynamic injunction. But because of this dynamic injunction, what is required is, the for the second infringement which is done, where the domain name has been changed. So every time the domain name changes, the producer or the copyright holder has to just inform the registrar of the court that this is the new domain name, and based on this previous order, this domain name should be blocked. So they block the domain name, new domain name, immediately. So that is a new remedy and dynamic remedy which is being granted. Similarly, in August 2023, this year, a new a revised version of dynamic injunction was granted, which was dynamic plus injunction. Because dynamic plus injunction basically says that if a particular producer can show that there is a particular website which is making available certain movies, so even if my work has not been made available, I can still obtain an order, injunction order, and that order will be known as dynamic plus injunction. So when my work comes up before the for the public, then I have to just inform the authority, the court authorities. They will be blocking it immediately. So that is a dynamic plus injunction order which has been obtained. Now another type of interesting issue is with respect to the sports data analytics. It is a very new area, because sports data analytics basically says that the data which is available for a sport event, for example, if we see in cricket matches, the everything has been recorded there. The length of the six, what is the length of the six, the boundary, the speed of the ball, the move of the player, everything has been recorded. So if anyone comes up, utilizes that data, and he comes up with that particular analytics, then whether he can claim any IP protection over that data. For example, if you see this image here, if a particular person is bowling left hand side, and then in that case, what is the ratio of the ball coming in play, and he's not being out, and in play but he's out. So this is the scenario based on the previous matches which has been played by the player. So again, for right hand side, what is the scenario? What is the swinging strike, the called strike, and the foul of the particular player? So all this basically helps the agencies, the teams, managers. So in IPL, you will see. I'm sure you must have seen certain web series also, most popularly Inside Edge, where there are certain team. Every team has certain data managers. What they do is they collect the data of each opponent team based on the previous matches, the recordings. They watch the recording, they see the analytics, and based on that they prepare the diet regime of the person. So that kind of data analytics is known as sports data analytics. And if you see the popular movie Moneyball, you'll see this kind of technology, which is the sabermetrics, which is basically telling the uh, analytical study. It is the analytical study of players, involving players and their performance, in order to determine their strength and weaknesses. So based on the players match, players performance, I can say that what are his strengths, whether a player, cricketer, if there is a batsman, for example, Virat Kohli, what is the possibility of Virat Kohli getting out on a spin ball? What is his possibility of getting on a Yorker and on other type of ball, on a uh, uh, other type of ball? So in that case, that analytics is known as sports data analytics. So that data is being utilized with the help of AI and machine learning technologies. So it involves the question that whether such data can be given any protection or not. So this is the questions involved here. Most of the jurisdictions have said that this kind of data cannot be given any protection because uh, it is only a collection or compilation of the data which is existing in public domain. So based on this data, what all can be predicted? What predictions can be done? It can predict the injury. It can also predict the value of the player. The team strategy can be formalized based on the data. The ticket value can be determined. So if a particular team has Virat Kohli, Rohit Sharma, and other popular player, then what is the possibility of the people coming to the match, and what is the possibility of the team of the audience not coming to match if these players are not there? So based on the previous performance of these players, it can be said the ticket pricing can also be determined based on that, based on the individual valuation of each player. And the last is it also helps in sports betting. So based on the performance of Virat Kohli, it can be said that what is the possibility of him getting a century and or not. Now, sports data. There were certain questions involved with respect to sports data. I'll discuss one of it. The first is the National Basketball Association versus Motorola. Now, sports tracks, if you see image here, Motorola had come up with a pager, which was the sports track. And what they did is they told the live scores. These pager basically told the scores, live scores of the matches which were being played by National Basketball Association, and they would show the live update on the scores of the matches. NBA approached the court and they sued Motorola on the ground that they are using the sports data over which NBA has a copyright, as a intellectual property protection. Now the question was whether it amounts to infringement of copyright or not. Court said that the uh, scores which are being broadcasted by NBA is basically is something which is available in the public domain. So even if Motorola is coming up with a pager technology which is showing these images and the live images which are being done, it does not amount to any kind of infringement of IP. Similarly, if you see in today's scenario, there are several websites which are there. Google has its own data analytics technology. Similarly, there is a popular website, ClickBuzz, which provides live update with respect to the matches which are being played. So all these technologies are not hampering or violating the IPR of either the ICC, neither of the Star Network, which is the official broadcasting partner of the World Cup. So based on this scenario, it can be said that using sports data can be of a very trivial question, because if the sports data is something which is available easily in the public domain, then using it without permission would not make any question of infringement. Similar opinions were also given in other judgments, which was CBC versus Major League Baseball Advanced LP, and the Toronto Real Estate Board versus Commissioner of Competition. I'll not discuss it because of the limitation of time. But with this, I end my presentation on the topic of IP and the sports business. I am open to any questions and discussion. Thank you.
Thank you so much, sir, for this insightful information. Now, I would like to request Sakshi Sharma ma'am, founder of esteemed Legal Vidya, to deliver a vote of thanks. Over to you, ma'am.
Thank you so much, Yashashvi. So firstly, thank you so much, Gururaj sir, that you took out time from your valuable schedule to come to Legal Vidya and give this valuable lecture to all our students. It indeed was a great topic, and we all had learned something new today. So thank you so much, sir, for this session, and we really look forward to being connected with you in the future as well. Thank you so much, sir.
Thank you, Dakshi.
Participants, if you have any questions, please write in the chat box or you can unmute yourselves and ask directly to the sir.